The underlying purpose of bankruptcy legislation is to allow a debtor to free him or herself from the excessive weight of debt. In other words, people can continue with their lives. So, if it is in the interest of society as a whole that people do not become prisoners of a debt spiral, thus unable to be productive members of society, preventing government institutions from shutting down and not being able to provide necessary services should be that much higher in the order of priorities. As a matter of fact, in a short article providing an overview of the purpose of Chapter 9 bankruptcy, the Administrative Office of the U.S. Courts states the following, and I quote, "The purpose of Chapter 9 is to provide a financially distressed municipality protection from its creditors while it develops and negotiates a plan for adjusting its debt. Reorganization of the debts of a municipality is typically accomplished either by extending debt maturities, reducing the amount of principal or interest, or refinancing the debt by obtaining a new loan." End of quote. I hope you enjoyed this preview of Puerto Rico Forward. You can listen to the full episode on Patreon, where you can also help support this project. You can also find us on iTunes and Google Play. As always, thank you for your time, thank you for listening, y que viva Puerto Rico. Now, you may have noticed that the word municipality has popped up repeatedly in our discussion so far. That's because it's a central concept in Chapter 9 bankruptcy. According to Merriam-Webster, the accepted and general definition of this word is the following, and I quote, "A primary urban political unit having corporate status and usually powers of self-government." End of quote. But of course, Congress sometimes decides to reject reality and replace it with its own. So in Section 101 of the U.S. Bankruptcy Code, they enacted their own definition of municipality, and I quote, "A political subdivision or public agency or instrumentality of a state." End of quote. The Administrative Office of the U.S. Courts adds clarity to this definition, and I quote again, "The definition is broad enough to include cities, counties, townships, school districts, and public improvement districts. It also includes revenue-producing bodies that provide services which are paid by users rather than by general taxes, such as bridge authorities, highway authorities, and gas authorities." End of quote. The fact that the term is so wide and encompassing is appropriate given the fact that only a municipality may file for Chapter 9 bankruptcy relief. Therefore, it seems logical to include as many vital government institutions as possible in order to prevent any of them from being unable to provide their service to the general public due to their indebtedness. But being a municipality is not enough. Section 109C of the U.S. Bankruptcy Code states the following requirements, and I quote, "An entity may be a debtor under Chapter 9 of this title if and only if such entity, 1, is a municipality, 2, is specifically authorized in its capacity as a municipality or by name to be a debtor under such chapter by state law, or by a governmental officer or organization empowered by state law to authorize such entity to be a debtor under such chapter." End of quote. This text, also known as the gateway provision, is vital for the case of Puerto Rico. What Section 109C is clearly stating is that even if a government instrumentality falls under the definition of municipality, it will not have access to Chapter 9's protection unless it is authorized to do so by the state to which it belongs. In other words, state governments are empowered to allow or prohibit their political subdivisions to file Chapter 9 bankruptcy. States hold the key to the door through which municipalities must go through in order to attain Chapter 9's protection. So put simply, Chapter 9 bankruptcy is a way for financially burdened government agencies or government instrumentalities to seek help from the U.S. Bankruptcy Court and address serious fiscal issues. In order for such institutions to have access to said protection, they need to fall under the definition of municipality and have been granted permission by the state they belong to. But guess, just guess, who doesn't have access to Chapter 9 bankruptcy? That's right, Puerto Rico. And that's because in 1984, the Bankruptcy Amendments and Federal Judgeship Act was passed, amending the U.S. Bankruptcy Code. And among the many alterations made, one amendment would prove to be both baffling and profoundly important for Puerto Rico's future. Section 421J of the Act states the following, and I quote, "Section 101 of Title 11 of the United States Code is amended by inserting the following. State includes the District of Columbia and Puerto Rico except for the purpose of defining who may be a debtor under Chapter 9 of this title." End of quote. As we can observe, Puerto Rico is specifically removed from the definition of the term state in regards to its ability to allow its political subdivisions to seek Chapter 9 bankruptcy protection. Incredibly enough, no one, and I really mean no one, is able to explain why Congress decided to approve this amendment. There is no legislative history that directly addresses it. No one knows. In reaction to this, and the same year that the rating agencies downgraded Puerto Rico's bonds to non-investment grade, in 2014, Puerto Rico's legislature enacted the Puerto Rico Corporation Debt Enforcement and Recovery Act, or Ley para el Cumplimiento con las Deudas y para la Recuperación de las Corporaciones Públicas de Puerto Rico. Said law created a debt modification procedure allowing public utilities to suggest changes to the terms and conditions of their outstanding debt. This process was not unilateral, but rather required consensus among the debtor and most of its creditors. Puerto Rico's legislature even went so far as to create a court-supervised restructuring process that mirrored Chapter 9 and 11 of the U.S. Bankruptcy Code. But, as expected, it was not long until a group of investment funds brought suit against Puerto Rico and many government officials to enjoin the enforcement of Puerto Rico's Recovery Act. The case is called Puerto Rico versus Franklin, California Tax-Free Trust, and is an absolutely convoluted horror. The central question to this case was the following: does the preemption provision apply to Puerto Rico? A simple question to which the Supreme Court of the United States provided a very labyrinthine answer. Both sides of the case gave opposite answers based almost entirely on the definition of the term state. Puerto Rico, in this case, the petitioning party, interpreted the definition of state to exclude it altogether from Chapter 9, thus placing it beyond its preemption provision, giving Puerto Rico the ability to enact its own municipal bankruptcy scheme. On the other hand, the investment funds, as the respondent party, believed that the definition only stripped Puerto Rico from its ability to specifically authorize its municipalities to seek Chapter 9 relief as recorded by the gateway provision. However, their argument continues, Puerto Rico is no less a state for purposes of the preemption provision, thus barring Puerto Rico from being able to enact its own municipality bankruptcy scheme while at the same time closing off access to Chapter 9 bankruptcy protection. The majority opinion favors the respondent's argument and concludes that the Bankruptcy Code's gateway provision has a narrow effect to eliminate Puerto Rico's ability to allow its municipalities access to Chapter 9 bankruptcy, but nevertheless kept intact its preemption provision over Puerto Rico. Specifically, the majority opinion, delivered by Justice Thomas, offered the following reasoning, and I quote, "We interpret Congress's use of the who may be a debtor language in the amended definition of the state to mean that Congress intended to exclude Puerto Rico from this gateway provision, delineating who may be a debtor under Chapter 9. Puerto Rico, therefore, is not a state for purposes of the gateway provision, so it cannot perform the single function of the state under that provision to specifically authorize municipalities to seek Chapter 9 relief. As a result, Puerto Rico's municipalities cannot satisfy the requirements of Chapter 9's gateway provision until Congress intervenes. The definition specifies that Puerto Rico is not a state for the purpose of defining who may be a debtor under Chapter 9. The text of the definition extends no further. The exception excludes Puerto Rico only for the purpose of the gateway provision. Puerto Rico is no less a state for purposes of the preemption provision than it was before Congress amended the definition. Had Congress intended to alter this fundamental detail of municipal bankruptcy, we would expect the text of the amended definition to say so." End of quote. In other words, within the same legislation, Puerto Rico is, and at the same time is not, a state. This is the only way one can justify the majority's legal thesis. In their eyes, Congress has decided that Puerto Rico cannot be considered a state for the purpose of the gateway provision, but is nonetheless among the states in regards to their impediment to create their own municipal bankruptcy scheme. Puerto Rico somehow occupies two different legal spaces at the same time. But not everyone was convinced by this logic-defying argument. Justice Sotomayor, joined by Justice Ginsburg, filed a dissenting opinion that uses a contextual view on the matter. The crux of her legal thesis is the following. Chapter 9's preemption provision cannot apply to Puerto Rico due to the fact that Chapter 9 only applies to states that can decide to whether or not authorize its municipalities to request said chapter's protections. The dissenting opinion provides the following arguments in favor, and I quote, "To understand why Section 903 does not preempt the Recovery Act, it is important to consider that statutory provision in context. Section 903 says that states continue to possess those powers not implicated by the bankruptcy itself, by noting that this chapter, i.e. Chapter 9, does not limit or impair the power of a state to control its municipalities. Section 903, however, also subjects that broad reservation to an exception articulated in the preemption provision that the court now says bars Puerto Rico's Recovery Act. But this distribution of power between the state and the bankruptcy court is irrelevant to Puerto Rico. Because Puerto Rico's municipalities cannot pass through the Section 109C gateway of Chapter 9, nothing in the operation of a Chapter 9 case affects Puerto Rico's control over its municipalities. And if this preamble does not and cannot apply to Puerto Rico, it follows that Section 903's proviso qualifying that reservation of power to the states does not apply to Puerto Rico either. End of quote. However, Justice Sotomayor's logic fell on deaf ears. Puerto Rico is thus shut out of Chapter 9's protection, while at the same time unable to take matters into its own hands. In other words, Puerto Rico can neither seek help nor help itself. That's it for today, but remember, if you have any questions or you want to suggest some future content, you can always write in at puertoricoforward@gmail.com. As always, thank you for your time, thank you for listening, y que viva Puerto Rico.